The GST we've been saying again and again is like a kabhi haan, kabhi na, and it depends on which date we are, which day and speaks on whether GST will happen, not happen. It's like the Brexit vote where the odds keep changing every day with a new opinion poll coming in. The GAAR, I may tell you, has been nothing short of a roller coaster ride over the last 5-6 years. One of my colleagues tells me that the first time that the GAAR provisions came in was, I still remember, I was still in television, and it was in 2009 August when the first draft of the DTC, I think, was released, and that is when GAAR was first introduced. But it did not see the light of the day, nor did DTC. But there is something that happened in between, and in January 2012, we had the Vodafone judgment of the Supreme Court, and within a month, within 45 days, you had the union government, the finance minister, Pranab Mukherjee, now the president, bringing in GAAR in the legislation, in the finance bill, and of course, then with the outcry that happened over the retrospective amendments, the outcry that happened over the GAAR provisions, and literally the foreign investors almost got spooked, and you had the GAAR being deferred again and again and again, till Finance Minister Arun Jaitley again deferred it and said we will introduce it along with BEPS, and that date is April 2017. And for all the people in industry who thought it will again get deferred, that's not happening. Sorry to disappoint, because the CBDT is coming up with some rules or the other from now and then, and they've come up with an amendment to Rule 10U. This was a couple of days ago, stating that the provisions of Chapter 10A shall not apply to any income accruing or arising to, or deemed to accrue or arise to, or received or deemed to be received by any person from transfer of investments made before April 1, 2017. Basically, they have changed the grandfathering date from August 30, 2010 to April 1, 2017. Must be a big sigh of relief for the industry, for the tax professionals. We are joined by two renowned tax experts, Dinesh Kanabar from Dhruva Advisors and Ketan Dalal from PwC. My colleague Amay joins us to give technical insights and to pose tough queries for both of them. Amay, your take quickly on this. What exactly does this amendment to Rule 10U say?
Right. So Arun, as you read out, the Rule 10U carves out certain exceptions in situations where GAAR shall not apply. For example, Rule 10U says that GAAR shall not apply if the value of transaction is less than 3 crores. Now, one of the important points which was being asked for by the industry is the grandfathering of the investments. The Shom Committee report also specifically mentioned that GAAR provisions or the GAAR law should be made prospective in effect. In other words, the investments made before the date on which GAAR becomes into effect should be grandfathered, should be protected. The date, however, earlier that was mentioned for grandfathering was this date of 30th August 2010. That's the date on which one of the earlier versions, so the second edition of DTC was released, and therefore the minister at that time said that the grandfathering only should happen for the investments which are made before August 2010. Now that anomaly has been corrected and has been sort of fast tracked or fast forward to align the date with the date on which the GAAR becomes effective, which is April 1, 2017.
Dinesh, you're happy, Dinesh? This assuages all your concerns and whatever demands you have. Dinesh, you can hear us?
Sorry, I couldn't follow the question.
Yeah, Dinesh, your first comments on the circular or the amendment to Rule 10U. You are happy?
The way I would put it is that the circular addresses one important aspect which applies maybe to foreign investors, which is to say that whether if investments have been made prior to the introduction of GAAR, whether the income arising thereafter is or is not exempt. But that does not really address the entire issue. The question is what happens if there are transactions which have taken place prior to GAAR. Let me put some very specific point here. Let's say there is a merger or a demerger or a slump sale which has happened prior to the introduction of GAAR, accepted by the tax authorities, but the consequences of which are going to happen year after year after year. Then will those consequences be examined again in the light of GAAR provisions? And I wish that while the circular does address the concern of equity investors, and maybe that is what the government had in mind. It does not address the larger issue as to how to ensure that the applicability of GAAR is prospective and not retrospective. So I'm happy with the circular, but I would think it just goes halfway house and does not address the entire issue.
Ketan bhai?
Yeah, I think you see somehow the feeling has been that somewhere people have confused GAAR with cross-border investment and tax treaties like a Mauritius and a Singapore, and of course subsequently Mauritius has been amended. But really GAAR is much broader. It's not only investment, it's arrangement, it is existing contracts, it is existing agreements. As Dinesh said, it could apply to the continuing consequences of a merger or a demerger, and it obviously does not apply only cross border but obviously also applies to domestic transactions. So while grandfathering up to 31st March 2017 in relation to transfer of investments is a limited carve out, so to speak, it's actually it's an indirect way of saying that for everything else GAAR applies. And I think the key point that I want to make is, see, GAAR is something which in concept I don't think anybody can, sort of dispute. The real issue is going to be how it is implemented on the ground, because from experience we know that it is not the letter of the law, it is not even the spirit of the law, but what actually happens on the ground that is actually going to be critical, as in everything else in the tax legislation in India.
But Ketan bhai, if you look at the fundamental concept, and I'll come to Dinesh bhai also on this, I just had a word with Mr. R. Sridhar, the head of tax at Coca-Cola, and he wanted us to put this to you all. He said that you have BEPS, you have SAR provisions, you have a LOB now in the treaty. He said, is there any need now for a general GAAR above all these things? And he quipped with this line. He said that the department has two AK-47s when they need only one.
Yeah, you see, as you rightly pointed out, and as Sridhar rightly pointed out, the ambit of SAR provisions, the ambit of LOB clauses, etc., is also very significant. It's quite significant. So therefore, in one way of looking at it is that you don't need it. But the other thing is that the number of things that can be impacted by what the tax department may consider as tax avoidance is actually also quite large. But I think one of the points which is important is that the government must clarify the guidelines, and I'm aware that representations have already been made to that effect, that where there are, let's say in tax treaties, LOB clauses, where there are SAR provisions like say section 93 for example, or for that matter transfer pricing provisions for example, wherever there is a SAR provision, the general concept is that the special override the general, and if the SAR provision for whatever reason is not applicable, one cannot say that there is a residual GAAR provision. So to that extent, I would absolutely agree. But there are things beyond SAR that can be applied. As I said, the real test is going to be how it is applied on the ground.
Dinesh bhai, I'll come to you and then go to Amay. Dinesh bhai, with respect to what Ketan bhai said on SAR versus GAAR, you had Mr. Rajat Bansal, Joint Secretary, telling us in an interview just a few weeks ago in the aftermath of the Mauritius Treaty Amendment that GAAR would prevail over LOB. That is exactly what he said. Dinesh bhai?
Yeah, I had a similar interaction with Mr. Akhilesh Ranjan when we were speaking on the same panel in Mauritius, talking about whether the LOB conditions, if complied with, would mean that GAAR does not need to be complied with. And his answer was exactly the same, that GAAR would have to be GAAR threshold would have to be met even if the LOB threshold is met. And so I would not agree with Sridhar when he says that once you have LOB, once you have SAR, do you need a GAAR? Yes, you do need a GAAR. But what is equally needed is that where SAR is there, GAAR ought not to apply. This was the basic recommendation of the SHOM committee. This is exactly what SHOM committee recommended after extensive deliberations with various constituents. It's there in the report. And now we are going and saying that no, notwithstanding SAR being complied with, you have an additional threshold in GAAR. And equally, LOB, once that is complied with, GAAR ought not to apply. So to that extent, I would agree with Sridhar that you are having multiple compliances on the same issue, and that I don't think is fair to any taxpayer at all.
Amay, you want to put a question to
Right.
Dinesh bhai, Ketan bhai?
Right. So just on continuing on this point around grandfathering and the larger concern that Dinesh earlier mentioned at the beginning of the hangout, if you read the wordings of Rule 10U, we have this amendment, today's amendment that we are discussing, wherein the grandfathering date has been shifted to April 2017. But then there is another Rule 2, sub Rule 2 in Rule 10U, which says that without prejudice to this, the provisions of the GAAR chapter shall still apply to an arrangement, irrespective of the date of the transfer. And I was trying to reconcile both these sub rules, so to speak, and what is the final impact that has. So, Dinesh bhai, Ketan bhai, does it still leave a scope, and does it make the GAAR grandfathering in a way academic and a redundant provision? How do you harmonize these two?
No, the way I would look at it is that the circular, to the extent that it is beneficial and provides for grandfathering, would definitely apply. And I don't see any doubt about that at all. The point is, what do you mean by grandfathering? Are we referring merely to grandfathering in the context of merely investments made and divestments of such investments? Or are we talking about grandfathering of any transaction which has been undertaken prior to GAAR, the implications of which come after GAAR? And the two are very different things altogether. And that is where the crux of the issue lies.
Okay, Ketan bhai, Ketan bhai, coming to one more point, and that is with regard to legislative versus judicial GAAR. You have Gautam, you had Gautam bhai telling quite a few times that wasn't judicial GAAR better. I mean, now you have a legislative GAAR, and therefore you have a handle in the hands of the tax officers to definitely to examine, scrutinize structures, and the final word usually was with the courts, and of course it will still remain with the courts. But now you have a legislative GAAR. Would you have preferred a judicial GAAR, Kiran bhai?
Yes, there are a couple of points here, Arun. The GAR which is now on the statute book is very, very widely worded. So, for example, I often get worried whether the line and the Rubicon line between, let's say, tax mitigation and tax avoidance can be crossed because the wordings are so sweeping and so wide. So, to that extent, I definitely prefer the judicial GAR because there was a tempering of that interpretation by courts. However, there is one point in the statutory GAR which I like and which I hope will temper down the applicability on the ground, and that is the concept that GAR cannot be applied unless it has got the blessings of an approving panel.
Yeah.
Because the very fact that you have to write to the approving panel, I'm hoping will be an appropriate restraint on, shall I put it, indiscriminate applicability of GAR. So I think the answer to your question, Arun, is that as such, I would have preferred a judicial GAR because the statutory GAR is too wide. But now having no choice but to have a statutory GAR, at least one is grateful that there is the concept of an approving panel for which a lot of representations were made, and fortunately the government accepted that representation, and the concept of approving panel is very much there on the statute book.
Dinesh bhai, continuing on the same theme, which are the couple of points in the current GAAR that spook you or spooks the industry still? That still leaves a big question mark hanging over a lot of the structures, as Ketan bhai said, that the line between tax avoidance and tax planning or tax evasion have always been thin. From Westminster till Vodafone, that line has only got more blurred. So in that sense, Dinesh bhai, which are the couple of provisions in the current GAAR legislation that still spook you, and are you happy with the safeguards that are there, like the one the Ketan bhai mentioned, the approving panel? Are the safeguards enough?
So let's take the one of the thresholds of GAAR, which is tax abuse, abuse of tax law. Now, what do you mean by an abuse of a tax law? And again, if you see, this is where a lot of work had been done by the Shom committee. So, when I was representing before the Shom committee, I had made a point with regard to, for example, a tax holiday, as to whether you set up an undertaking in a tax holiday or elsewhere is something which you are going to make, taking into account the tax benefits and the IRR as a result of the tax benefits. Now, are so are we going to see such issues come up? And there could be, I mentioned to you earlier about, and this is something which worries me day in, day out. If, for example, you have restructured a company 3 years back, as a result of which your depreciation entitlement changes. 2 3 years have gone by, tax office has accepted. Now can somebody come back and say that although you may have complied with all the provisions with regard to a merger and a demerger, and therefore there are no negative consequences, but we would regard the fact that you are entitled to maybe say a higher depreciation or a carry forward of tax loss for a higher number of years. We would like to examine this in the context of GAAR and therefore not allow you that benefit or ask you to re-justify an arrangement which took place 3 years back. And that could be
Good.
very, very difficult. And these are not theoretical issues, Arun. This is something
Yeah.
which, as practitioners, we encounter day in, day out. So, a very specific thing. In the context of a merger, your tax holiday revives for a period of 8 years post merger. A merger is made in a tax neutral manner. 3 years later, somebody comes back and says, no, these losses ought to have lapsed because the merger that you did constituted abuse of tax. How do I ever justify this?
Yeah, probably you could say that it was sanctioned by the High Court under 391, 394, but that's fine. As I said, am I basically, hearing Dinesh Bhai and Ketan Bhai, I think we are left back with that big question: more litigation.
Yeah, absolutely. More litigation, and I think one point I would like to ask Ketan Bhai is we have roughly about less than 300 days now before the GAAR kicks in, and if nothing has been done so far, the businesses need to act now and make sure that the structure is GAAR compliant. Any specific 2 or 3 things that you think should be focused upon while doing transactions in the next 9 months that we have? Number one, and number two, this in the context of court GAAR, which is still being active, what are the additional considerations that one needs to keep in mind?
Before I answer your question, Ame, I just want to make a mention of the point that Arun made earlier. Arun, what I mentioned was tax avoidance and tax mitigation, not evasion, because evasion is anyway illegal. So I just
Absolutely.
want to make sure that that point is driven
Yeah,
home.
yeah, absolutely.
Coming to the questions that you asked, Ame, you see, today there is already a judicial GAAR, and I think shorn of a lot of legalities, one of the fundamental principles of GAAR and a defense against GAAR is the following: is the transaction something which is a commercial transaction, albeit it may have tax advantages, in which case GAAR should not apply, as opposed to a transaction which is tax driven and shorn of the tax benefit of the transaction does not seem to have a commercial rationale or a commercial substance. If the latter is the situation, then regardless of whether it is judicial GAAR or legislative GAAR, there is an issue. So, to answer your question, whether things need to fall in place before that, I think that is the fundamental litmus test that the taxpayer must ask and should have asked anyway, regardless of the fact that GAAR is coming in. So I think perhaps that may be the key point to ask. So if, for example, you are renewing an arrangement today, the key question is this arrangement a commercial arrangement? Albeit, of course, it may have some tax benefits. And if the answer is yes, then at least fundamentally, conceptually, you don't need to worry about GAAR. Of course, what the tax department will say to that is a different issue altogether, but that one can't guard against anyway.
Dinesh Bhai, burden of proof is on the tax department, right? So that should alleviate some concern.
So let me just look at the breadth of questions that you have asked thus far, Arun, and just let me put a context to that.
Yeah,
You're talking about the fact that there was earlier a judicial GAAR.
yeah,
Was that a better situation than a statutory GAAR?
yes,
And the fact of the matter is that over a period of time, the judicial GAAR and the McDowell principle was considerably whittled down. The subsequent judgments, including in the case of Vodafone, substantially whittled down the McDowell impact, number one.
yeah.
Number two, Ketan made a mention about approving panel. And you are now asking me a question as to whether the fact that the burden of proof is on the revenue, does it mitigate the concern? What tends to happen in practical life, and this is not law, this is, as Ketan was mentioning earlier, how the law gets implemented, is that the tax department, by virtue of what I may say as mere allegation, put out saying that they have decided the prima facie burden of proof, and then the burden of proof shifts from the revenue to the taxpayer. Number one. Number two, I have seen in practice that when a matter gets to a panel, while panel could really apply itself much better and sort of not merely rubber stamp what the officer has put, two comments. One is our experience with DRP thus far, including the last few orders which have come, last cycle where the orders have come, has not been very, very encouraging. And number three, would it be really that the approving panel really strengthen the case of the revenue or really be fair in terms of what has been put before?
Okay, perfect. I think we've lost Dinesh Bhai signal for a moment. Yeah, Dinesh Bhai, I still wanted to persist. I wanted to ask both of you, what Amay asked, and a little more directly, what are the two things you're telling your clients? Dinesh Bhai, so if you're meeting a client today, you're meeting the tax head, CFO, CEO, what are you telling him? How do you get GAAR ready? How do you make your structure GAAR proof?
So, what we are saying is essentially is that the need for substance and the threshold on substance is far higher than what one would have looked in the past. That do not simply rely on this proposition that if your transaction is done pre-GAAR, it will not be examined post-GAAR afresh, and therefore weave in whatever more you can as opposed to less. Presume that you are going to be challenged. Presume that every transaction will be viewed with a microscope and go on that basis.
Perfect. Ketan Bhai?
Yeah, I think the GAR threshold, as I said, is higher. It's quite sweeping. So if I might to give you an example, let's say there were no thin capitalization rules. There are no thin capitalization rules today, but the GAR does have a provision of debt is to equity and the potential recharacterization of the interest deduction. So today, for example, if a capital structure of a company is, let's say, 1 crore equity and 100 crore or 50 crores debt, I would certainly get concerned about the potential recharacterization, and therefore, in substance and in terms of the rationale of a debt equity ratio, I would tell my client that look, this does not appear justifiable, although there are no thin capitalization rules, because under the larger sweep of GAR, this has the potential to be attacked. So it may be a good idea to relook at the capital structure. Things like that. At the end of the day, I perhaps may have said it even had the legislative GAR not come, but with the legislative GAR which has come, I might repeat that point and reiterate that point three times as opposed to mentioning it once, and try and persuade the client not to walk down that path. So to that extent, the level of rigor in looking at transactions, I would think has certainly increased because of the legislative GAR and its sweep.
The level of rigor has increased, says Ketan Bhai. Amay, one quick word on GAR, last word, and then we move to Dinesh Bhai and Ketan Bhai's views on Brexit, and we'll close the hangout. Amay.
Yeah, no, Arun, just short comment. I think there's been a lot of criticism on GAR. A fundamental point is that whether country needs a GAR or not. If we have a further toned down version of GAR, then the question is that we might as well not have a GAR in it rather than having something. So I think there are safeguards. I think the concern is on the administration per se, and hopefully maybe we will be surprised with the administration hopefully in the coming years. But otherwise, on the law itself, I think we have a better version than what we saw 5 years ago.
Yeah, no one less than the Prime Minister has, at the Rajasva Gyan Sangam, has exhorted the tax officers to change their mindset and not look at the taxpayer as an adversary, as a person who does not pay his tax faithfully or dutifully. So exactly. So maybe that message will go across to the department as well. In fact, I was at the department a few days ago, and a senior officer said that there is a sea change in the attitude, and probably that will come across when GAR is administered. Ketan Bhai, I cannot leave you and Dinesh bhai, without asking you about Brexit. Last for 72 hours, all we've read in the newspapers is about the Brexit catastrophe, the calamity that's hit the financial markets. What's your view, Ketan bhai? And what's the larger impact? What are your clients telling you again? What are you hearing from foreign investors? How spooked should we really be on a Brexit? Number one, and number two, on tax policy, do you see any impact whatsoever?
Okay, before I just go to Brexit, just one point, in the guidelines, I just wish that the kind of examples that the Shom committee came up with is the part of the guidelines that the CBDT would issue, and I could not resist making that point before the GAAR part of the Hangout is over. So I just thought I'd make this point, and also on how penalty will be levied, because 50% for underreporting and 200% for misreporting, etc. There has to be a lot of clarity on that, because otherwise the penalty could be immense and really, really damaging. Coming to Brexit, well, I don't fancy myself as some kind of a larger political or economic commentator. So I can only say, and I'll come to the tax part in a moment. But I think gone are the days when one could say that if I insulate my part or my country from the rest of the world, the laws can be more aligned to what I require. And I think the fact that there is a UN cry for a second referendum, and I don't know whether that can even happen, is a clear indication that the vote to leave is people are having second thoughts about it, because it is going to impact cross-border flows for sure, both in terms of, let's say, employment, in terms of trade, and for that matter in terms of taxes. So, for example, let's say the parent subsidiary directive, the interest and the dividend non-withholding, the merger directive amongst the EU, all that will be impacted. And also remember that from an indirect tax standpoint, such as customs barriers, etc., the trade between the EU will get impacted. In fact, I was talking to a client, and he has a very large subsidiary in the UK, and that subsidiary deals with its step-down subsidiaries elsewhere in the European Union, and they are in the process of reviewing what the impact of Brexit is on all those transactions, because you may need to rework the entire ecosystem of dealing with your own subsidiaries in the EU. So I think the impact will be very substantial. I
Thank
think more on the indirect tax front, less on the direct tax front.
Absolutely, yeah, probably on the VAT front as well in the UK.
Yeah.
Thanks so much, Ketan bhai. Amit, it's been a wonderful Monday evening hangout. Always a nice way to start the week. Thank you everyone for joining in.
Thank you.